right, hello, welcome to Hollywood, Highways, and Generative AI Outputs, What's Next in AI Law? I am Nadira Imam, president of the Beverly Hills Bar Association and Beverly Hills Bar Foundation. I'm delighted to be here today to help introduce this program, a partnership between BHBA and the Federal Communications Bar Association. At BHBA, we greatly value opportunities like this to collaborate with other bars, as together we can provide timely, engaging, and informative programs for our members and the broader legal community. For those unfamiliar with BHBA, we are approaching our 100-year anniversary with over 7,000 members throughout California and beyond. We are home to the largest entertainment law section of any bar association and have more than 40 other active practice area sections. We averaged more than one new CLE per day and recently won the Best CLE Provider and Best Online CLE Provider with the Best of 2025 awards from the Recorder. We welcome your submissions for topics and speakers that interest our members and those of other great organizations we partner with, like FCBA today. Getting the added benefit of specialized expertise from bars like FCBA is excellent for our audience and our collective knowledge. So thank you for attending today. We hope to see you again. I thank you to the FCBA for working with us to put this great panel together. I am sending a particular thank you to Jonathan Cohen, who is a member of both BHBA and FCBA and led to the development of today's content. And now I'll turn the floor over to FCBA's president, Matthew Del Nero.
Yeah, thank you, Nadira. I'm delighted that FCBA is collaborating with the Beverly Hills Bar Association on this very timely topic of what's next in AI law. It's really an honor for the FCBA to be partnering with a bar association that has such an impressive history in leadership and public service throughout Los Angeles County and beyond. Our own bar, the FCBA, dates back not quite 100 years, maybe a little closer to 90, to the 1930s, just after Congress adopted the Communications Act. And since then, our members have really been at the forefront of legal and policy developments in communications, media, and more recently, tech sectors. And we're fortunate to have many committees, and among them, the Emerging Issues in Technology Committee, which develops compelling programs and events focused on the most cutting-edge issues for our bar. And it's thanks to that committee that the FCBA has joined BHBA today for this event. As you might see, I'm speaking to you here from my office in Washington, D.C., where probably the majority of our membership reside. But one thing that we are all very proud of is the FCBA's national reach. And that extends, of course, to Southern California, where we have many active members. One of those members is Jonathan Cohen, a partner at Wilkinson Barker Knauer. Jonathan actually divides his time between Los Angeles and Washington, racking up a lot of frequent flyer miles, and he serves as a co-chair both of our Southern California chapter and of our Emerging Issues in Tech Committee. Jonathan's going to be moderating today's panel, which I'm really looking forward to attending, and I will turn the mic over to him now.
Thank you, Matt, and hi, everyone. Thanks for joining us. And thank you also to both the BHBA and the FCBA, the Tech Bar, for agreeing to collaborate on this webinar. We're lucky to have three respected academic scholars to teach us about some of the new and novel legal issues that artificial intelligence is raising and will continue to raise. I'll briefly introduce them, but longer bios are linked in the CLE materials that have been distributed. So joining us are Jess Miers, an assistant professor at the University of Akron School of Law. She's a recognized expert in online intermediary liability law in the U.S., who writes and speaks on such issues as online speech and Section 230, intellectual property, content moderation, and cybercrime. Her recent research and scholarship has been centered on generative AI. Also with us is Mark MacCarthy, an adjunct professor at Georgetown University in both the graduate school's Communication, Culture, and Technology program and in the school's philosophy department. He teaches courses in technology policy, content moderation for social media, privacy, the ethics of speech, and the ethical challenges of AI. He also is a non-resident senior fellow at the Institute for Technology, Law, and Policy at Georgetown Law Center, as well as a non-resident senior fellow in governance study at the Brookings Institution Center for Technology Innovation. Mark is the author of the 2023 book, Regulating Digital Industries: How Public Oversight Can Encourage Competition, Protect Privacy, and Ensure Free Speech. Finally, last but certainly not least, is Eugene Volokh. He is the Thomas M. Seibel Senior Fellow at the Hoover Institution at Stanford University and the Gary T. Schwartz Distinguished Professor of Law Emeritus at UCLA Law School, where for over 30 years he has taught First Amendment and copyright law, criminal and tort law, and firearms regulation policy. Eugene has written extensively about law and artificial intelligence since 2019. Welcome to you all. So we have a packed agenda and we're going to get right into it. Each of our panelists will give a talk addressing topics from our agenda, and after each we'll have a short discussion amongst the panel. There should be time toward the end for audience questions, so please submit your questions using the Q&A button at the bottom of your Zoom screen. We have a lot of attendees, but we'll do our best to get to your questions. First, I'd like to kick things off with an opening question for all of our panelists. Unlike previous technological leaps, AI enables humans to engage with automated systems that can understand content, exhibit apparent reasoning ability, and respond in ways that feel genuinely conversational rather than purely mechanical or transactional. And AI applications are being adopted at a very high rate. So, as a general matter, do you think that the rapid changes occurring because of AI will make the courts in the future inclined to revisit existing precedents while applying different standards, leading potentially to surprising new results? Or are we just stuck with the precedents that we have? And if the former, what do you think that means for attorneys litigating on behalf of clients? Eugene, let me go to you first.
AI is going to be about as broad as internet, probably more so, right? Used to be people say, oh, I practice internet law. Do you practice internet law? Now we realize everything is internet law, right? So I think the same thing is true with regard to AI. Obviously, there are huge copyright law issues raised by AI, heavily litigated right now. There are some libel law issues. There have been 4 libel law cases in the US that I know of so far. Then there are questions having to do with alleged physical harms that are created by AI applications. There's a lawsuit pending right now, Garcia v. Character AI, having to do with liability for suicide that may have been causally linked to conversation with kind of a chatbot, a character-based chatbot. In that case, conversation by a minor, that might make a difference. And then, of course, there are other problems, right? I hope everybody is aware of the dangers of filing briefs with hallucinated citations. Latest database that I've seen has shown over 300 court decisions throughout the world noting this and sometimes sanctioning lawyers for that. About over half of them, I think, are in the US. But that is just a special case of the broader problem, that there's a lot of error having to do with AI that can infect our work product, that just can affect the facts of a case. I was just reading a court decision this morning, which has to do with a quite traditional cyber squatting case. But the cyber squatters, what they were doing is they were libeling someone by talking about this lawsuit against them, but it was all fake. Like all of the filed purportedly filed documents on their site were AI generated. Again, it's an old thing. Forgery is a very old thing, but AI makes it easier, makes it perhaps more common, changes the frequency. So it's going to be everywhere. It already is in some measure everywhere. It's going to be even more everywhere.
Mark, thoughts on this?
So yeah, let me say first, thanks to you for having me on this panel, and And thanks for the book plug as well. I'm appreciative of that, and looking forward to chatting with Eugene and Jess on these issues. So back in 2023, the then chair of the Federal Trade Commission, Lena Khan, I think she summed up the best attitude toward AI and the law when she observed, there is no AI exception to the laws on the books. So are companies using AI to establish creditworthiness? Well, then the Consumer Financial Protection Bureau can and should make sure the companies abide by the fair lending laws. Are the companies using AI to screen workers for employment or promotion? Well, then the Equal Employment Opportunity Commission can and should make sure that these companies don't discriminate against protected classes when they use these new technologies. Or companies using AI to make pitches to consumers about the quality and price of consumer goods. Well, then the FTC can and should make sure that the companies are not engaged in unfair or deceptive acts or practices when they use these algorithms. Now, how to apply existing law might be unclear, as Eugene noted for the case of copyright law and content liability, but there's no AI immunity. In particular, I don't think there's any AI immunity under Section 230, since AI systems generate content rather than distributing the content of others. By the way, Lawfare recently published a useful survey of how current consumer protection laws apply to AI, and that might be worth distributing to the group. So do we need new AI laws? Well, it depends on whether we want to impose new obligations on AI companies. For example, discrimination using AI is illegal, but right now only employers are liable. Do we want the vendors of AI employment tools to be liable as well? Well, then we need a new law.
Jess, anything to add?
Yeah, first of all, I agree. Thank you so much for having me. This is a great event, and I am with some really, truly fantastic people as well. It's kind of a little starstruck here. So, on this topic, I want to echo Mark and Eugene. I think I agree entirely. And on the Section 230 note, I will say I wrote an article a couple years ago when the generative AI stuff was booming, and I had said, of course, Section 230 applies to generative AI. This is now the subject of my research, how generative AI specifically, how we treat it under the First Amendment and how we think about it in terms of immunities and safe harbors. And I would say today, I think my views have probably changed a little bit just in understanding how the technology works. It's probably not Section 230, but I do think we need something that's Section 230-like if we're going to keep having this technology. But going back to the original question here of where are we with the current law and how does it apply to AI? Well, first, I'll point out AI is a discipline, right? So AI does not refer to any specific kind of technology. And I think that's really, really important for folks who are on this call and are really thinking about the types of technology that they're engaging with when we talk about AI. There's many different ways to implement artificial intelligence into different technologies, and those different ways matter tremendously. I'm going to cabin my remarks to generative AI, so the type of technology that allows us to generate new content. You can think of that as your ChatGPTs, for example, your large language models, your multimodal models. And so there's some interesting questions right now in First Amendment law. I know Eugene is probably going to speak about this as well, about how we treat those types of new communications technologies. And Jonathan, you were asking, are we stuck with current precedent, or are things going to change? I think the history of what we've seen with every single new iteration of communication technology tells us that even if we think the current First Amendment precedent should apply in full scope in the way that we see it apply to newspapers, we see it apply to internet services, there's always been a little blip or speech mutation along the way for the history of regulating communication devices. And so I think what we're going to see with generative AI is probably really another sort of mutation, especially looking at the way in which the courts are treating this technology. Eugene was talking about the character AI case, for example. There is a big discussion in that case about whether generative AI outputs are even considered speech. And I was stunned by that because to me, of course, they're considered speech. Of course, there's the way that this technology is built by the providers and developers of these tools. They're making very precise editorial decisions that lead us to these outputs. And yet we have sort of this, what Joseph Weizenbaum in 1966 called the ELIZA effect, this sort of reaction to chatbots where human beings, they project sort of these emotions onto chatbots, and they sort of lose their minds when it becomes, when we're in this sort of generative context. And so seeing as where the courts are going now and the way the current legal discourse is about generative AI, I certainly don't think we're going to be stuck with the current precedent. I think we are going to see sort of a whatever the next adaptation is to this new brand of communication technologies. And I think the character AI case is going to be the case to watch for that.
Fascinating. Thank you. Well, we've used up 15 minutes of our 90 minutes already, so let's launch into our presentations. And Jess, let me ask you first to bring up your slide deck, and we'll sit and hear you educate us.
Awesome. And I'm going to try not to take the full 15. We'll see. And thank you for the Beverly Hills Bar Association for running the slides. You can go ahead and go to the next slide. I appreciate this. So I'm going to be mostly focusing on digital replicas and the publicity rights question of generative AI. And so I know many of you who are on this call, you're probably associated in some way with the entertainment industry. There's a lot of fascinating ways in which generative AI tools are being used in entertainment. And of course, with those fascinating uses, if there comes some potential liabilities and risks. And so that's what I'm trying to call out in these slides today, just to kind of give an FYI about the law developing in this space. That's especially important because, as you all know, we don't have a federal publicity rights statute on the books yet. We don't even have a federal privacy law statute on the books yet. And so what publicity rights has become is sort of this really wonky mix of privacy and First Amendment and IP all sort of bleeding together in the different state applications of publicity rights law. So if we take a step back for a second, we can think about, well, how is AI being used in the entertainment industry? And we've seen things like de-aging, for example. So there's been lots of instances where AI is used where you have the actual actor is in the movie, but they may have been de-aged. We've seen what I think folks are most familiar with, or probably recognize the most, this idea of deep fakes, digital replicas, this idea that you can clone another person now. And these AI technologies have gotten really, really good at that. I've seen the voice cloning technology. I'm sure you all might remember, the Biden voice calls that were coming out. We've gotten very, very close, if not almost indistinguishable to actual human voices. We've seen folks use this voice cloning technology in the music space, especially where they're sort of ghostwriting new music and accrediting it to these performers who they weren't even part of it in the first place. So there's lots of different ways that AI is being used. Another big one is resurrecting deceased performers, and that has a lot of sort of personal, ethical, and legal implications as well, where either you're resurrecting them in sort of a concert setting, or you might be bringing them back to life in a movie, video game setting as well. The point is that with all of the traditional issues that come up in publicity rights, it's exactly what Eugene was saying. We still have those exact issues, but now AI is making it easier. It's making it better. And it's also making it more affordable and approachable for the general public as well. A lot of these tools, all of us today can download and use them as well to do a lot of the stuff that really was reserved for Hollywood. So I have some examples, some of these celebrity flashpoints. Scarlett Johansson was a big one. She never actually sued OpenAI, but OpenAI had a Sky voice that resembled her. The big one right now is the LeBron James pregnant Diddy memes. I can't believe I even said that sentence out loud. That one, LeBron James LeBron James actually sent a cease and desist letter, and we're waiting to see how that sort of plays out, but sent that to the providers of the tools that are allowing people in order to make these sort of memes and strange content. We've seen this with Tom Hanks. We've seen this with other celebrities where viral advertisements are going around that are, they show the celebrity sort of endorsing a product that they have never endorsed before. They never made the video. Talked a little bit about the heart on the sleeve music context. And then another sort of recent, SAG-AFTRA went after Epic Games for negotiating a license to keep James Earl Jones' voice for the Darth Vader video game series, but they did not. The Epic did not go through SAG-AFTRA, so that ended up being an issue as well with their collective bargaining agreement. The tools that we have available to deal with these types of deep fake issues, it's going to be your state publicity rights statutes that are already on the books. But then what we're also seeing are states trying to come up with their own AI specific additions to those publicity rights laws. Now, a lot of them have to do with voice, because a lot of the state publicity rights laws don't include voice. It's usually your name, image, and likeness. So we're seeing some attempts where it's just to bring voice into this already existing state statute, or to just address AI on its own. And that's going to be things like the Elvis Act. California and New York have some new laws on the books we'll talk about as well. The Federal Lanham Act, of course, is also in play. That's going to be more narrow uses, though, what we're seeing. That's going to be specifically in the advertising context. And then we also have the Take It Down Act, which was recently enacted in May. I'll talk a little bit about that in a bit. And the No Fakes Act, which is currently proposed, not enacted. And it, as far as I've heard as of today, it's probably not going anywhere, but I'll put it on the radar anyways. It's kind of a zombie bill. It comes back every year. And then the other thing to sort of throw out there, we saw in the early days of bringing these IP suits against the generative AI companies, they would sort of mix this artist style claim, and they tried to bring that in as a publicity rights claim. And most of those have been dismissed outright as just trying to end run around copyright. So we're seeing courts decline the artistic style. That's for situations where you could ask a generative AI tool to create a comic or art in the style of a famous artist's work, or a poem in the style of a famous author's work. Those are being rejected as publicity rights claims. And then the last thing we're seeing is these takedown, these notice and removal regimes start to emerge, but now in the publicity rights context. And that's what we saw with the Take It Down Act, which we'll talk more about. But this is the idea that not only are the providers of these generative AI tools potentially liable for enabling people to create these images, or to sort of violate the publicity rights of other individuals, but it's also extending to the internet services that then host these deep fakes as well. We can go to the next slide. This is one example case that's pretty recent, as of July 2025, Lehrman and Sage versus Lovo. Lovo is a voice clone app. I'm just putting this in there just to demonstrate one of the many cases that has to do with these voice cloning apps. Paul and Linnea Sage, they're both voice actors. They were asked on Fiverr to contribute their voice. They were told it was for some sort of research project. They actually didn't know that it was going to be used in the context of being part of this voice cloning app. They brought a lawsuit against the voice cloning apps. That's the Lovo app. And they brought it under breach of contract. And then also New York's right of publicity statutes. That's section 50 and 51. And they also brought a copyright claim. The courts decided no on the Lanham Act claims, said that is reserved for, they said first, it's no actionable consumer confusion in that case, and reserved in advertising context. So we see the Lanham Act not being successful. But the publicity rights and the contract claims were allowed to stand. So we are still currently watching this case. This will be I think this is one of very few where the publicity rights actions are still in play. And then most of the federal and trademark theories were also dismissed as well. We can go ahead and go to the next slide. So here's some of the laws / guidance currently on the books or pending. The big one to keep in mind is the Take It Down Act. So that was enacted in May of this year. There's two parts to it. The first part actually criminalizes the creation and publication of deepfakes that have to do with non-consensual intimate imagery. Oftentimes, this is sometimes referred to as revenge porn, and that was the intent behind the Take It Down Act when it was initially proposed. It was initially proposed to deal with some of the issues that are taking place in schools today, where kids are using these quote unquote undressing apps, undressing AI apps, where you can provide a real image of somebody and then the AI can then sort of fill in the rest. And those were going around. And again, it's in this sort of revenge pornography umbrella of content. Some of the problems, though, there is no carve out for First Amendment, parody, commentary. There's some vagueness around what is actually considered an intimate image. And the reason I have the recent screenshot from the first episode of South Park, I actually wrote an article a couple months ago where I sort of suggested the Take It Down Act, given how broad it is, could actually apply in political commentary situations like South Park. I spared you all the actual image that I think is potentially at issue here. But in the very first episode of South Park this year, the creators actually used a deep fake of Donald Trump nude. They were kind of doing like an emperor's is nude, has no clothes, where they actually showed genitalia, AI created genitalia. And there's sort of this open question about, well, in that context where the Take It Down Act does criminalize the creation and sharing of intimate imagery of known people, of known individuals, could the Take It Down Act apply in that context? So it's kind of a warning or a heads up to those who are, even thinking about political commentary or thinking about doing something like South Park did. There are these sort of criminal penalties that are currently on the books. The other half of Take It Down actually refers to the online services, so the social media companies. The social media, this creates a notice and takedown removal scheme where it's extremely broad. The folks who are the subject of deep fakes or intimate imagery that's being shared can contact a social media company. Social media company has 48 hours to remove that content. It's pretty strict. There is no sort of question about whether it's First Amendment protected, fair use, et cetera. It's 48 hours to take it down or they're held liable. So that's currently on the books, and we haven't seen any actions under it yet. The No Fakes Act is currently pending, but I don't think anything is going to happen with it. Knock on wood, watch something happens tomorrow. This is an attempt at creating a federal digital replica right. Remember, we talked about how we don't have a federal publicity rights law. So this is an attempt for us to get a federal publicity rights law that is aimed at AI. And it would also restrict the creation, and publication of deepfake content. And it also applies to the internet services as well, creates a similar DMCA style takedown approach. Again, not sure that's going anywhere. I included the FTC impersonation rule because there were discussions about whether the FTC was going to extend their existing impersonation rule, which only applies to government entities and businesses. There was a discussion earlier this year about whether they would extend it to individuals. They had a hearing, I think, in June, and the decision was not to extend it to individuals. So that is only in play for impersonation of government entities and businesses. And you can go to the next slide. Jonathan, how am I on time?
You're good. You're good.
Okay.
We may have to forego the sort of follow-up question, but that's okay. This is great.
Okay. Awesome. Great. This is a little bit older. It's from 2024, the U.S. Copyright Office. They went through a bunch of series for, it was mostly having to do with how copyright and fair use and infringement applies in the context of generative AI. They also addressed publicity rights in the first part of their report. And so they essentially talked about we don't have federal publicity rights laws, and there was a suggestion about maybe we need a federal publicity rights law on the book. It talked a little bit about how currently the only thing we have in play are the different state laws, and it discussed some of the limits on those state laws. For example, a lot of state laws have some limitations on post-mortem rights. When somebody is dead, how do their name, image, likeness rights sort of extend to the estate? And so some are really, some are kind of the gold standard, like California when it comes to post-mortem rights, and then there's others that may not even contemplate postmortem rights. And then, of course, other states, it has to be used in a commercial context. And then some states, it can be used in either commercial or other contexts as well. So the Copyright Office was sort of highlighting the limits, but then also noting that there are state laws that are on the books to address some of the publicity rights issues. They include existing laws do not provide sufficient legal redress for those harmed by unauthorized digital replicas, and they are recommending new federal laws. So the Copyright Office is sort of behind a lot of the discussions with no fakes, for example. The entertainment industry is pro no fakes, and I believe the internet industry, the internet services are also behind no fakes as well. And you can go to the next slide. Here's the Elvis Act. Now, this has been in play for a while now. It went into effect July 2024. As of my research yesterday, I don't think I've seen any recent actions under the Elvis Act. This is Tennessee's approach to ensuring that voice gets protected in their already existing publicity rights law. This was brought and favored on behalf of many of the music artists in Tennessee. So this was a very big deal in that state. This covers digital and AI generated reproductions, so deepfake and synthetic media. I will note this doesn't get talked about a lot, but there is a part of the bill that also extends third-party liability to the providers of generative AI tools that enables people to make voice clones and deepfakes. That one is not talked about as frequently, but just an FYI, again, if you're representing a generative AI company, you too can also be in scope for this. Prohibits the exploitation of likeness, but mostly voice without consent. And the Elvis Act is kind of what set the precedent for all of these other states that have been proposing and enacting their own voice and generative AI publicity rights laws as well. So Elvis kind of kicked it off. For remedies and penalties, there is a private right of action. There's also a third-party right of action too, which is fascinating. It kind of goes beyond what we see in publicity rights, existing publicity rights statutes, but record labels can also now bring suits on behalf of the individuals that they represent as well. And it's a Class A misdemeanor. So the Elvis Act in Tennessee are taking digital replicas, specifically having to do with voice, very seriously. And again, this is kind of our first approach to seeing an AI specific publicity rights law in the books. Next slide. We also have New York. So this went into effect January 1st, 2025. New York's digital replica law is very similar. I think it mirrors the California law. This specifically has to do with contracting with the use of artists, actors, and making production companies making digital replicas of those artists and actors. So for example, in this law, it's going to void any contracts that meet the following of these conditions. And the California law is very similar too. So we're going to, if the contract is allowing for the creation and use of a digital replica of an individual's voice or likeness in place of work the individual would otherwise have performed, this mimics, by the way, the SAG-AFTRA collective bargaining agreement around AI in general, then we will potentially void the contract for that as well. This is to the sort of the policy reason behind this is they don't want to ban the use of AI in entertainment, but they don't want, you take a single, like let's say a single face scan or a body scan of an actor, and then you just use that in place of the actor for anything going forward, where the New York law is not going to permit that as part of the contract. If the contract also does not include a reasonably specific description of the intended use of the digital replica, that's also going to be a problem. So that you can't just articulate in your contract that you are going to make digital replicas or you're going to take a scan of the actor or the performer. You need to specifically say how it's going to be used and the use cases that are going to follow. You can't leave it up to future uses, for example. And then the last thing, if it was negotiated with an individual who was not represented by legal counsel or by a labor union. So this kind of gets at the SAG-AFTRA Epic Games controversy where Epic just went directly to James Earl Jones's estate and didn't go through SAG-AFTRA. The same thing is happening here with this New York law. You cannot, if you're going to include AI and digital replicas in your entertainment contracts, this needs to be negotiated with individuals' counsel or with a labor union as well. And you can go to the next slide. These are things that are going on in California. So California had a whole spate of laws regarding generative AI or regarding AI use in entertainment. AB 2602, exactly, it pretty much codifies the rules that are already in place with SAG-AFTRA, and also it's very similar to the New York bill. So again, if you are contracting with performers in California, not only do you have to deal with the labor union rules around using AI and how you use digital replicas of those actors, but now we also have California AB 2602 on the books, which also requires you, even for non-labor union performers, also requires your contracts to be very clear about how you're using digital replicas, and you cannot replace an actual person for future uses as well. AB 1836 just expands California's already very extensive and existing publicity rights statutes on the book. It prohibits the use of a deceased personality's voice or likeness without consent from their estate or family. This is, again, trying to get at some of the controversies around resurrecting people and musicians for some of these like future these like holographic concerts and in films as well. So you now need to have express consent from the estate in order to do that resurrection with AI. And the last one here that I flagged, and there's a bunch more, by the way, I'm just picking the ones that I think are probably the most on point for entertainment. AB 2905, that requires disclosure when AI-generated synthetic voices are used in telemarketing calls. So again, if you're going to be placing telemarketing calls in California, we have a lot of disclosure laws around the use of bots. I will also just flag, it's not on the slide, but California also, and I believe New York, and I think New York is in litigation with X on this, but there's also some election deepfake related laws as well. So when you're blurring the line between entertainment and potentially politics, you could run up into some of the election deepfake laws too. Next slide. I went ahead and put this together. I won't read them all out because you all can read and you'll have access to these slides. But just from my own research and the way I've been thinking about things, I kind of put together what I call quote unquote safe use cases. This is not legal advice, by the way, so don't come after me if you get sued, but sort of your safer cases and then some of the more risky cases. And I will say that I think of the most risky side, that's going to be these entertainment contracts. There's a lot of them out there where there have been specific issues where you're either running up against SAG-AFTRA, which, as many of you know on this call, they are very, very, very brutally serious about the use of AI. It is not something that's favored in the labor union. So even if you're not seeing a law in the books, if you're dealing with someone who's within a collective bargaining agreement, you need to be very careful about their rules. They're very strict about it. Anything where you're dealing with an unauthorized voice clone, you're dealing with unauthorized replicas of performers, obviously going to be a problem. Even if they do consent, you might still be in a collective bargaining agreement issue. Commercial advertisements have always been risky before AI, now currently with AI. So you would not want to deal with that. You not want to do somebody who has not consented, specifically, especially actors, well-known actors. AI-generated pornographic deepfakes are really that's one of the big use cases, both federally and in the states, is they're really going after pornography. They're going after NCII and specifically CSAM with children. So I would say that's kind of on the riskier side. On the less riskier side, of course, if you've got consent from the estate, you have consent from your labor unions, then using it to de-age folks is kind of the golden standard right now, a better use case. You're not replacing the actor, you're not replacing future actors. Generative VFX for stunts, dubbing, translations, that's all kind of above bar as well. And then I have parody, satire, and non-commercial commentary, but I put a big maybe because have fun litigating it. And I think that's probably the end.
Yes, I think that's your last slide.
Sweet.
Thank you so much, Jess. That was jam-packed. And I think we're going to just move directly into Eugene's presentation. So Eugene, you're going to be talking about liability issues relating to AI outputs. So take it away.
I'll be happy to. So I am going to do, in a sense, kind of the opposite of what Jess was just doing. I'm going to focus on one major thing and drill down pretty deeply in it. Jess's presentation is in many ways much more useful because this thing, while it's a potentially major topic, is something that's only led to about 4 cases so far, but I think people will find it interesting. And it may be that there will be more of these coming around. So, all right. I think I should be switching. I am in slideshow, but somehow I'm in presenter format. Is that right?
So right now we see the PowerPoint application itself. We don't necessarily see the slideshow or presenter view.
Okay,
think
so
it's
how
toward the
about
bottom.
from beginning? How's that? Is this better? Can you see?
Yes, that is better.
Fabulous. So the name of this is borrowed from an article I wrote 2 years ago, Large Libel Models. Of course, we know that AI hallucinates. Well, what if hallucinates about particular people? And what if hallucinates things about them that are not just hallucinated, not just false, but potentially damaging to their reputation? Here is one example from a case that was filed, but actually recently settled. Obviously, we don't know. On what terms? Starbuck v. Meta Platforms. Robbie Starbuck is a prominent conservative political activist. And in his complaint, he says, look, I see this post on X where this third party, I don't know him, is saying about me that that I was involved in the January 6th riot, that I'm linked to the QAnon theory, that I'm anti-vaccine. It's all false. But he got it from Meta. That is what Meta is saying about me. And in fact, there was evidence that that's what was happening. Eventually, Meta stopped saying that in its text output. But then the complaint says their voice output began to generate the same things. So again, this is not like garbage in, garbage out, that there's something somewhere online that contained this false information and Meta is faithfully parroting it. It's gold in, garbage out. The training data, the online data may have been quite accurate, but the algorithm produced false things from it. So if you think about it, if this were a newspaper that published this, it could be a libel claim, right? False, factual assertions, probably damaging to reputation. Participating in a riot is a crime. Then, of course, there'd be questions. What was the mental state? What mental state is required? He's probably a public figure, so this would require so-called actual malice, basically knowing a reckless falsehood. If he were a private figure, maybe negligence would be enough. Well, how does this play out with AI? My answer, I think, is pretty much the same as with anything else. But only pretty much. There are some interesting possible differences. So this case is settled. Let me give you another example. This is from it's as best I can tell, it's still currently pending. I last looked into it about a month or two ago before the Norwegian data protection authorities. They're the ones who apparently in Europe are in charge of hearing these cases. There's this question, who is Arve Hjalmar Holmen? And ChatGPT says he is accused and convicted of murdering his two sons and attempting to murder his third son. I have good news. Everybody's alive and well. Again, this was just something that was just made up about Holman, totally made up. There are a couple of earlier cases, one of which was dismissed in part because of very peculiar facts, where it was pretty clear that from almost the get-go, the person posing the queries understood this was a hallucination, so no real damage to reputation. Another one was then shunted off into arbitration, where presumably it's going to wither. But there's a fourth one that I don't have slides on, in part because it's not quite as visual. But basically, there's this company, I think called LTL in Minnesota, and they also operate under Wolf River Electric. They install solar panels. So apparently, they say if you enter Wolf River Electric, Google would then autocomplete to lawsuit, Wolf River Electric lawsuit, and then would report in that AI summary paragraph generated up on top that they were being sued by the Minnesota AG for various violation of consumer protection laws. It's false. They were never sued, nor had they been accused of being sued. There was apparently a newspaper article which talked about a lawsuit about somebody else, and then they were quoted, but there was no claim in that article that they were sued. There is this hallucination. Again, by the way, in some respects, not terribly new. People misread things and kind of things get mushed together in their heads and then they pass them along. Sometimes it happens with reporters. Not uncommon, for example, with there to be being libel lawsuits where there's a case of mistaken identity, where a reporter kind of thinks somebody is involved in a case where it's really somebody else with a similar name or some connection. But in any event, that case is pending. Unlike the other ones, the plaintiff claims they have real information, real evidence that they lost business, that there were people who canceled contracts with them, saying it's because Minnesota AG is suing you. People said, canceled kind of negotiations with them, and they say it's millions of dollars. It's important because, as just to foreshadow a bit, as we know, in libel cases, even brought by private figures, when it's on a matter of public concern, you can recover proven compensatory damages on a showing of pure negligence. Whereas for presumed or punitive damages, even for private figures, you still have to show knowing or reckless falsehood. So here they're saying we're a private figure, we're just a local small business, and we can show damages. So that'll be a case to watch. So here's one other one. This is the one that went off into arbitration. Basically, there are these allegations about there's this perfectly correct statement about a man named Jeffrey Battle. And then there's another statement about a different man named Jeffrey Battle, slightly differently spelled, but doesn't much matter. In fact, everything is correct except the word however, and probably the implication from the word battle that it's the same battle. But that's plenty to make for a libel claim. Again, fortunately for Microsoft, apparently they had an arbitration agreement that led the case to be sent off there. So how would the law analyze that? I'm going to skip Walters. That's the one that was dropped. So one way of thinking about it, imagine, just to simplify things a bit, an analogy, check BKG, background checker, run by a company called Open Records. Basically, check BKG takes a name, reviews court records, provides a list of the criminal and civil cases in which the person has been found liable. And let's say it acknowledges the information may be erroneous, but also touts how good a job it generally does. Someone uses check BKG, search for Joe Schmo, gets a response, criminal conviction, civil liability. But it turns out that that's just not true. That's just an error in the algorithm. How do we analyze this? Well, we'd say Open Records is publishing false and reputation-damaging information. They may not be publishing in the sense of placing it on the web, but for libel law purposes, communicating it to one person counts as publication. Doesn't matter that it's through a computer program, I'm pretty sure. I mean, again, we can talk some more about that, but it's responsible for what it's for what it does. It's just like with self-driving car. If you get hit by a Waymo, Google can't say, no, we didn't do it. The car did it, right? They let the cars loose. They programmed the cars. They're going to be responsible, subject to interesting questions having to do with mens rea, but they can't just sort of shift the blame to an inanimate object. It's not protected under Section 230. I think we all agree on this. And I think Mark captured the point very well that this is generative AI is generative. It's the one that generates things. Section 230 means you're not liable for things somebody else generates. But here, just to take the Open Records example, you look at any of the other examples, the output was in fact generated by the defendant. Noting the information may be erroneous, I think we'd say isn't enough. We'd say, okay, sure, you might note it, but the only reason people are using your software is because they think it may very well be accurate. You're making money from the possibility that it's accurate. A mere disclaimer is not sufficient. We'll get to that in a moment. Now, it knows that its software is outputting false statements. I got the name wrong, about Schmo. And if Schmo alerts it to that, and then they keep outputting it, maybe you could say that is knowing or reckless falsehood on the part of the creators of the software or of the company that's operating the site. And it might be liable in a negligent design theory as well, if Schmo is a private figure, and again, if the Schmo can prove damages. So I'm going to skip the Section 230 immunity, skip the publication requirement. Happy to get back to that if people have more detailed questions. Let me mention a bit more about the inadequacy of disclaimers. The law has long recognized there's liability for repeating a slanderous charge, even though identifying the source or indicating it is merely a rumor. That's well-settled libel law. Another way of thinking about it is we do sometimes use disclaimers in traditional defamation. Rumor has it. That's a form of disclaimer. It's not disclaimer, rumor has it, but still say rumor has it that so-and-so committed this crime is flagging that it may be false, although it may be true, right? We know that some rumors are false, but we also know some rumors are true. Spreading that rumor is sufficient for liability. The publisher is subject to liability. In fact, even though he expressly states he doesn't believe the statement that he repeats to be true. That's from the restatement. I think that may be going too far. Maybe there's reason to cut back on that, although again, there is case law that supports that. But at the very least, if all you're saying is, I might be mistaken, but here is this thing that sounds like a factual assertion, liability. And just to quote the GPT or OpenAI's kind of fact sheet on GPT, or not even fact sheet, it's a long, pretty detailed analysis of GPT that I put out in early 2023. I think they're quite right to say hallucinations can become more dangerous as models become more truthful, as users build trust in the model when it provides truthful information in areas where they have some familiarity. I think that's an important point. And I think it's especially so. So, I mean, I wrote the article when you had to go to ChatGPT and enter a query there. Now Google automatically outputs it at the very top of every search result. That sounds like kind of a not quite anti-disclaimer, but that would counteract many a disclaimer. If you're so confident in the general reliability of your output that you automatically put it out there, supposedly for the benefit of your users and therefore of yourself, it becomes much harder to say when you're sued, oh, no, everybody knows this is, highly unreliable. If it's so highly unreliable, why do you output it so often? So then, of course, all of this is applying normal libel law and normal First Amendment principles. And the premise is there is First Amendment protection for AI output, but there's an exception for defamation that applies for AI output just as much as for ordinary human output. But some might say, well, maybe AI output shouldn't be constitutionally protected, in which case maybe we should allow more liability for AI than for traditional materials. I don't think so. So this is from an article that Mark Lemley, Peter Henderson, and I co-wrote, where we say, generally speaking, AI output is constitutionally protected. It's true, it's not the direct product of a human mind. If all you cared about was self-expression, maybe you might say that's not enough. But it's valuable to readers, contributes to their search for truth and the like, and the law has generally recognized that free speech is protected because of the rights of listeners as well as of speakers. It lets readers gather information, compare cameras. There's all this case law that says you have the right to photograph things in public places, and the government can't impose restrictions and impose liability for that unless it fits within some exception. Why? Because it allows you to gather information for your own purposes, but also to then further retransmit it. That's true of AI output. And it lets readers create their own speech. Just to take the example of Garcia, where again, there may be a special complication because this is a minor, interesting question. We can talk about that later. But the whole point of these chatbots is precisely that. By chatbot, I'm sorry, I mean specifically not just something like ChatGPT, but something where there's a character that the person interacts with and has a conversation, an engaging conversation with, is precisely so readers can create their own speech. In this situation, they create speech to them by the AI, but based on their input. And sometimes, of course, people use it to create other speech, sometimes in ways we academics don't much like, such as when our students use AI to create speech that they really should be creating on their own if they want a grade for it. But more broadly, there are all of these perfectly legitimate means of use or reasons to use it. Basically, if you want to come up with a post or an op-ed or whatever, presumably you'd edit it some as well as prompting, but it is valuable to you. Of course, it's also shaped by AI companies' own design and training decisions, sometimes quite in overtly ideological ways. So I think there may be some rights of speakers there, but there's certainly rights of users. Here's one way of thinking about it. If AI output is just unprotected, period, then presumably Congress could pass a law saying AI cannot output anything that is anti-government or anti-police or racist or anti-Israel or anti-Palestinian or what have you. I mean, after all, if there's no First Amendment protection, then even viewpoint-based restrictions would be permissible. I think our reaction is that can't be right. Why not? Because that would allow the government to really influence public debate. It would interfere with listeners' rights to hear all sorts of views. I think that shows that it's constitutionally protected. Now, I suppose you could say, well, it's protected, but less protected or differently protected. I just don't think that's right. I think for all these reasons, it should get full protection, but still subject to exceptions, such as for libel. There's more to say. One thing I do want to mention is if you if you have a knowing or reckless falsehood standard, for example, for statements by public figures, I do think it leads to a kind of notice and blocking type requirement that once the company is aware that false statements are being said about someone, it may need to take reasonable steps to try to stop the distribution of that, like having some post-processor that sort of removes things that it knows to be false statements that are being generated. For negligence, I think the best analogy, it's only an analogy, but I think it's a good one, is to design defect law for products. Again, like with a self-driving car. It's not strict liability. It's a liability for unreasonable design, but that's very similar to traditional libel negligence. So that's the way I think things will play out. Let me just mention also this might play out not just for libel, but for false light, disclosure of private facts. Similar questions come up with regard to things like false statements likely to lead to injury, maybe accurate statements likely to facilitate crime because they reveal certain information about people. So in principle, all of these things could apply to the other torts. So far, the cases we've seen involve defamation. So with that, I think I turn things over to Mark.
Well, actually, let me, if I may,
may.
ask you a question here. As I'm sure you know, and probably many in our audience know, at least one Supreme Court justice, Justice Thomas, has called for the court to revisit the actual malice standard from New York Times v. Sullivan. And, he says this at practically every opportunity. So if the court were to lower the bar for libel suits brought by public figures, what do you think, how might that play out in the AI context? And what do you think it would mean for practitioners, attorneys representing clients in that area?
Sure. So, by the way, it's not just Justice Thomas, but Justice Gorsuch has always also expressed skepticism, not always, but also expressed skepticism about New York Times v. Sullivan. Of course, back in the day, famously, the major adversary of New York Times v. Sullivan and other libel decisions was Justice White, kind of the centrist justice. Then Professor Kagan, back in the day, also expressed some skepticism about New York Times v. Sullivan, although I don't know that that means that Justice Kagan would want to reverse it. So if New York Times v. Sullivan is reversed, then probably what would happen is we probably wouldn't get back to strict liability. We'd probably have a negligence type regime, kind of like the one for private figures, except it would also apply to public figures. So a government official or a prominent person like Starbuck, for example, he was the one of those four plaintiffs that was relatively prominent, or maybe also Walters, the original one. Actually, the judge did say he was a public figure because he was an activist, would also be able to recover on a negligence basis, so long at least as they can show compensatory damages. Of course, if New York Times v. Sullivan gets rejected, then other cases might too, like Gertz v. Robert Welch. That might suggest that presumed and punitive damages might also be available on a negligence basis. That would, of course, be the whole point would be that that would be true with regard to newspapers and such. I think it would also be true with regard to AI. Now, to be sure, I should just stress, on the one hand, I'm glad you were listening to this talk. I do think it's interesting and important, but we're talking 4 cases. We're talking 4 cases so far over basically 3 years worth of advanced AI being public, advanced LLMs, let's say, being publicly available. Maybe it'll increase, but the one thing that I can say for sure is whatever you might think about the possible danger that relaxing Sullivan and Gertz and such would create for newspapers, maybe kind of cause them to really very sharply shy away from things for fear of bankruptcy. I doubt that these are going to be existential threats to AI companies. Not to the big ones, maybe smaller ones, but smaller ones would also presumably be generating a lot less stuff and therefore be less likely to get sued, at least for defamation. So I mean, we can have a debate about whether Justices Thomas and Gorsuch were right or whether Justice Brennan was right back in New York Times v. Sullivan and how it should play out. I do think that as a practical matter, that is probably a lot more of an issue for newspapers and and other news outlets than it is for AI companies.
Any of our other panelists care to weigh in on this? Okay, then we will move to Mark. Mark, you're going to talk a little bit about the regulatory environment and note that Mark recently wrote a piece for Brookings on the standards that should apply to liability for self-driving cars. Feel free to weave that in if you like. Also, as you know, out here in Los Angeles, you see Waymos all the time, and I understand they're coming to DC too.
Well, they're prowling around DC, but they're still in mapping mode, and so they're not wandering around without a driver. Not yet. But let me start with some remarks about the AI liability for self-driving cars, because as you say, they're wandering around Los Angeles, and you may be wondering, you know, what happens if something goes wrong? So one approach is to figuring out the standard for liability is their traditional product liability approach under a negligence standard. Under that approach, the plaintiff has to show that there was a design or manufacturing flaw in the self-driving car, and this flaw led to the accident that caused the injury or the property damage. But absent such a showing, the victims would not be compensated. There's another standard that I call the reasonable human driver standard. And under that standard, the car manufacturer would be held liable for damages whenever its computer driver fails to avoid an accident that a reasonable human driver would have avoided. And a reasonable human driver is one that's competent, unimpaired, and attentive. The victims would be able to, would have to demonstrate that the computer driver's behavior would have been unreasonable if engaged in by a human driver, but they would be compensated if they could make this showing. And this is a liability standard that I think judges and juries have some domain expertise to administer. Now, in my view, policymakers should adopt both approaches. They should maintain the traditional product liability standard, but supplement it with the liability based on a reasonable human driver standard. Now, there's one objection to that, which is that the reasonable human driver standard does not require self-driving cars to be better than human drivers. And that's, of course, true. Now, of course, the traditional product liability approach provides some incentive for all of the self-driving car companies to move up to the de facto industry standard. And also keep in mind that human drivers are pretty safe. Human drivers are involved in a fatal accident only about once in every 100 million miles driven. Now, even though that's pretty good, I think policymakers will rightly demand more from self-driving cars. And if they want this increased safety, I think that might be more effectively done through a regulatory requirement. For instance, if policymakers expect that computer drivers can and should react to a suddenly appearing pedestrian faster than a human driver would, well, regulators can design a test and make a specific faster than human response time a performance requirement for self-driving cars. So in short, I think a liability system has to be supplemented with a regulatory system to provide full protection for people and to drive improvements in the technology. I also want to say a couple of words about chatbot liability, because I think both of our other panelists have touched on that. And my general framework is to address the issue not assuming that chatbots are people, because they're not. They don't have consciousness and they don't have independent agency. So you can't hold them responsible for illegal conduct. But the companies that provide them should be responsible. I think, for example, Meta should be responsible if Meta AI, its chatbot, provides advice, guidance, or recommendations that would create liability if that were provided by a human. And I think this intuitive way of thinking about chatbot liability would accommodate speech issues in roughly the way that Eugene was mentioning. If a human speaker would have a free speech defense from liability, so would a chatbot, but as Eugene pointed out in his presentation, people don't generally have a free speech defense against defamation claims. So I guess neither would AI companies. So I'm in large agreement with Eugene on that stuff. So let me turn now to some of the national regulatory issues, and I'm going to do a quick summary of the administration's AI action plan. One of the first things that the Biden administration, that the Trump administration did back in January was to repeal Biden's executive order on artificial intelligence and replace it with, in July, with an action plan, which has several parts: innovation, infrastructure, international diplomacy, and security. So let me summarize some of those parts. One part you would expect from any Republican administration. They call for agency action to dismantle unnecessary regulatory barriers. But it also embraces an anti-woke principle. It says our AI systems must be free from ideological bias, and this seems fine as a statement of principle, but in practice, the AI plan seeks to revise the NIST AI risk management framework to eliminate all references to information, diversity, equity, and inclusion, and climate change. So it embodies a political agenda, not a praiseworthy commitment to neutrality. Interestingly, it welcomes open source models. It says that these models allow startups to innovate without being dependent on the big AI companies. And these open source models can become global standards and so have a geopolitical value. Gone completely are the worries that open models would create national security risks. In the area of infrastructure, the plan calls for special exemptions from permitting requirements for data centers. And it says that agencies with significant land portfolios have to identify sites suited to co-location of data centers and power plants. And DOE has already selected 4 sites for AI infrastructure development. It calls for grid improvements, but this is largely a statement of goals rather than concrete actions. It calls for aid and grants to the semiconductor manufacturers through a revamped CHIPS program that's been folded into a new program in the Commerce Department. In the international area, it calls for global US tech dominance. It says that the goal should be to export the full US AI technology stack, hardware, models, software, applications, and standards to all countries willing to join America's AI alliance. It does call for engagement with international bodies, but really to make sure that they don't impose burdensome codes of conduct on US companies. And it calls for more export controls, largely to ensure that our allies do not sell chips to China. In the area of security, there's a section calling for a rebranded AI Safety Institute, which is now called the Center for AI Standards and Innovation, to evaluate national security risks in partnership with AI frontier labs. But there's no suggestion that AI companies have to submit their models to the government for review or describe to the government what they have done to mitigate national security risks, as there was the case under President Biden. In biosecurity, there's a continuity with Biden's approach. He wanted to control access to DNA synthesis tools rather than putting the entire burden of protecting against biosecurity risks on the AI models. And President Trump's AI action plan duplicates that. So let me turn to some state regulations of AI. The big, beautiful bill that passed a couple of months ago sought to preempt state AI regulation for 10 years, but it was soundly rejected. So the state legislatures are a vector for AI regulation. And I'm going to touch on 2 major laws. The first one is Colorado's AI Consumer Protection for Artificial Intelligence Act. It was signed by the governor in 2020 May 2024. And it applies to AI systems that are used in certain key applications in education, employment, financial services, government services, healthcare, housing, insurance, and legal service. And it puts some duties on the deployers of AI systems, developers as well. Let's start with the developers. They're the people who develop the AI systems, and they have to disclose to the businesses that use its systems, that is to the deployers, any known or foreseeable risks of algorithmic discrimination. And they have to describe the measures they've taken to mitigate these risks. And these risks also have to be disclosed to the Attorney General. Now, the deployer, that is the businesses who use these AI systems, they have to have a reasonable risk management policy and program in place, specifying what they do to identify and mitigate risks of algorithmic discrimination. The deployer also has to complete an annual impact assessment, which includes an analysis and a review of discriminatory risks and the steps that they've taken to mitigate these risks. The deployers also have to make certain disclosures to consumers and provide them with certain rights. They must disclose to consumers when they are interacting with an AI system, except of course when it's obvious. And they must notify consumers that an AI system is used to make a decision about them before the decision is made. And they have to provide a notice of adverse decision to consumers, which notice has to include the data that was used to make the decision and the source of the data, an opportunity to correct the data, and how to appeal an adverse decision, even to a human reviewer if that's technically feasible. In addition, the deployers have to disclose to the Attorney General that an AI system that it is using has caused discrimination, and they have to do this within 90 days of discovering this. And they also have to share the annual impact assessment with the AG. The AG enforces it. The effective date was supposed to be February 1st, 2026, but a new law was passed in August that delays the effective date for 5 months to June 30th, 2026. That's so as to allow more time to consider revisions. There was an attempt to revise the bill in August, and the negotiations collapsed. And the delay to revise was urged by the governor and the AG. It's an enormously complicated and controversial bill, and it will almost certainly be revised before it's allowed to go into effect. The second state bill I want to talk about is from Illinois. It's the legislation that regulates the use of AI in mental health and therapy services. It was passed just this last August 1st of 2025. And the key provision has to do with therapy services. It says that a company may not provide therapy services, including through the use of artificial intelligence, unless the therapy services are conducted by an individual who is a licensed professional. And even a licensed professional may not allow an AI system to independently provide therapy or make therapeutic decisions or directly interact with clients in a therapeutic capacity, or generate treatment plans without human review, or be used to detect the client's emotions or mental states. Professionals can still use the AI for administrative support and supplemental services like note-taking. But the problem is not just that therapy companies using AI to provide services. That really isn't the focus of the problem. People, especially young people, treat general purpose chatbots as their therapist. So does the law apply to providers of chatbot services like OpenAI when a user uses the chatbot as a therapist? I think it depends on whether OpenAI is providing therapy services through its chatbot when the user's prompted to answer questions about their mental health. And that is not yet clear, at least not to me. And if it does apply to OpenAI, how could the company restrict the use of its chatbots to comply with the law? Let me note in closing that Nevada and Utah have similar laws, and it is widely expected that other states will follow suit and imitate the law that's been passed in Illinois. At the federal level, by the way, the FTC is getting into the act. They recently announced a 6B study targeting the treatment of children by AI chatbots. They're going to be sending some questionnaires to the major AI companies asking what they're doing in that regard. It doesn't mean that they'll take action, but it's an initial step that could lead to some action on their part. There won't be any national legislation in this area, I don't think, but I do think these kind of laws will spread at the state level.
Thank you, Mark. Mark, can I ask you a little bit more about your book, Regulating Digital Industries? The underlying premise of the book is that new laws are needed to promote competition, protect privacy, ensure free expression in the digital age. And some of your colleagues at Brookings, most notably former FCC Chair Tom Wheeler, has also advocated for the creation of a new digital regulator. That obviously would require an act of Congress, and as you just said, it seems unlikely for them to move in that direction in the foreseeable future. But what are the basic arguments that support your views on this?
Well, read the book. They're all. Thank you very much for the plug the second time. Let's take for an example competition law, which is given the recent decision in the area of Google's search. It's pretty clear that there are some fundamental limits on what antitrust can do in the fast-moving world of search, of internet, and now of artificial intelligence. It seems pretty clear to me that what is needed is some sort of regulatory oversight over the industry itself, and the competition policy, as it's currently structured, is really a matter of bringing a law enforcement case, getting a conviction, and then having a judge set a punishment. And that's just not a recipe for long-term oversight of the industry. If you want to promote competition in that industry, you have to have behavioral requirements overseen by a regulator. Even if you were able to split the different parts of the company into parts, there would have to be a regulator to regulate the interaction between those separate parts and to make sure that they don't reintegrate themselves. So at some point, you need to have an ongoing structure to oversee the industry, and competition policy is just not set up that way right now. So let me treat that as the answer to the general question of why you would need a digital regulator.
Do either of the two of you, Eugene or Jess, have a different view? Want to challenge Mark on that?
No, I don't, but I do want to mention something about the AI, the Waymo accidents. I don't know if people, actually, all of you folks are in LA, or at least, although maybe there are people from all over the country, but the Beverly Hills Bar Association, you cannot possibly have missed the rideshare Amigo, right? Like driving down from Beverly Hills down La Cienega to the airport. You see one stretch of 2 blocks with literally 5 rideshare Amigo bulletin boards there. I'm not sure if you've seen, though, but the rideshare, your AI car accident Amigo is also. No, I just had ChatGPT generated while I was listening to Mark, but this is the future. In fact, I will license this this artwork for you folks if you want to get into a new business.
There it is.
That's great. We did have only one question so far submitted in the Q&A, so I just want to reiterate to our audience that that's available to you. We have a question that I think was meant for Jess about publicity rights. It says, I thought publicity rights pertained to prohibiting advertising and commercial uses only, such as posters, figurines, endorsements, etc., not creative uses such as generated characters within a movie or TV show. Is that correct?
Doctrinally speaking, yes. And I will state, just as a FYI, some states, they'll even go beyond the commercial use aspect, and they'll say, they'll say they'll protect non-commercial uses as well. So just, it depends on the state that you're in. But no, for the most part, doctrinally speaking, creative uses, we do have First Amendment protections for commentary, satire, parody, and some of this creative expression. There's the famous Rogers-Grimaldi test that we apply as well when we're deciding whether we're in the commercial and the sort of like a commercial use versus a protected First Amendment creative speech use. But it all has to be litigated at the end of the day. So at least in the entertainment context, we got lots of money and lots of really great lawyers out here and on this call. But for folks who are, maybe smaller creators or smaller performers and artists, you can really, once you start getting close to that line, could mean very expensive litigation down the road.
Yes, Mark.
I've got a question for Jess as well. It's back on the Take It Down Act, which you did a good summary of, and the notice and takedown process that they set up is very similar to the one that's set up for copyright under the Digital Millennium Copyright Act. But that act has a number of sort of anti-abuse protections in it. I mean, there's a counter notice process where you can say, wait a minute, this is not infringing, and you can enter a whole process that ultimately will bring the whole thing to court. There's nothing like that in the Take It Down Act. Do you think if there's buyer's remorse about this act, which I think we both believe there will be, that would be an improvement that would make the thing a little bit more workable?
I mean, look, I'll be real with you. Even under the DMCA, there's that, they even have that, I think it's 512F, where even for frivolous claims, when you bring that in, that could be, you could potentially be sanctioned for that. And the courts have just failed time and time and time again, refused to apply 512F, even in situations where it is so clearly, obviously a frivolous takedown. So I would imagine that even if you had sort of that protection or guardrail in a publicity rights context, the take it down context, I'm not actually sure how useful it would be. And I'll also point out too, it's structured like the DMCA, but I think many will agree the DMCA itself has its own problems. The Take It Down Act, it doesn't learn any of the lessons that we've learned over the decades of dealing with DMCA. It doesn't require the person who brings a takedown to state that they even have a right to bring the takedown. Whereas in the DMCA context, you have to be an agent or you have to be the rights holder. There isn't that, as you were saying, there isn't sort of a guardrail in place for if it is a lawful takedown or not, if we're talking about protected speech or not. Whereas in the DMCA context, there's a little bit of wiggle room for fair use. There's essentially what I've been calling a stay down and monitoring provision, where it says that you not only have to remove the content that's been noticed or at issue, but you also have to remove any identical copies. And the person who's sending the takedown notice doesn't even have to say where those identical copies are or which ones or at what time. So I would actually say it tries to mimic the DMCA, but it doesn't even do that well. It doesn't learn any of the lessons that we've learned over the past several years from the DMCA's abuse.
Okay, so let me just ask another question to the panel. Given the breakneck speed at which AI models and applications are being developed, it may not be overstating it to say that AI is being used in nearly every aspect of society. Is there anything that, from your particular points of view, is being overlooked about AI law? Or alternatively, is there anything that keeps you up at night when you think about the direction that AI is going. That's for anyone and all.
Mhm.
I'll throw out there, I mean, the article that I'm writing about, so I'm taking the perspective that I actually think generative AI, and I'm staying in the realm of generative AI. I think it's a publishing technology, and I think it's very clear. Yes, we have the listener's case, and I think Eugene did a fabulous job really drawing that out. But I also think what's really being overlooked is the fact that the folks who are designing, developing, providing these tools, they are operating as new modern publishers in the same way that we saw with the internet context. And what's keeping me up at night is as we are getting into this sort of machine human distinction, AI is only getting better, and our technologies are only improving as ways to be able to communicate with each other, to publish information to each other. And so this isn't just going to be conversations about AI. A lot of the conversations that are taking place about generative AI are starting to fall back into these discussions that we were having about internet, social media algorithms, for example.
Right.
We've seen this whole discussion emerge around like treating generative AI like products and treating and just the same way we're talking about social media algorithms, like we need to apply products liability. And again, we're talking about communications tools. There's a reason why we don't apply products liability theories to newspapers, for example. And so I'm sort of worried about us losing the plot here as our technology gets better and better, and as it allows us to be able to communicate in more and different ways. And we're not just going to screw things up for AI, we're going to screw things up generally in the communication space.
So if I could just mention a little bit about kind of my perspective on liability for AI companies and such. Jess and I agree that there should be broad protection for AI companies as speakers, both on their own behalf and on behalf of listeners. This having been said, there are exceptions to the First Amendment. So one example is defamation. Another example, we don't know the exact scope of it. It is now being litigated before the court in a case, I believe, called Childs v. Salazar. But there may be some exception for professional client speech. That case involves, if I recall correctly, a state law that restricted conversion therapy, an attempt to basically change people's sexual orientation when they seek it out. But various legislatures have said, well, this is a bad idea. It's not going to be effective. So therefore, we're going to prohibit psychotherapists from engaging in it. And now it's before the court as to whether psychotherapists have a First Amendment right to engage in it. Maybe the court will say yes. But it might also say, well, when we're talking about professional client speech, maybe viewpoint-based restrictions like this one are impermissible, but maybe some other restrictions. The court might say, for example, this restriction is impermissible, but of course, if you can show that this psychotherapist was actually engaged in malpractice by doing something that reasonable psychotherapists would conclude is going to do more harm than good, well, then for historical reasons, that's a perfectly legitimate kind of claim. So let's say the court says, yes, there is essentially this exception for negligent professional client speech. You can speak negligently to the public at large. You can't sue a newspaper for having an incompetent legal advice column or psychiatric advice column, but you can sue a professional. Then one question will be, can you sue an AI company on a negligence type theory? Mm-hmm. And products liability, at least when you get to design defect, is essentially a form of negligence theory. It's not exactly, but it's oversimplifies it in some measure. But basically, it's all about the argument being that this is an unreasonable design. You designed it to essentially carelessly in a way that might breach professional duties or might cause physical harm and such. So you can imagine a case like Garcia v. Character AI, which says, look, this is something that is protected by the First Amendment, that is to say, communications with people, including ones that discuss suicide, but especially when the company can easily tell whether it's a minor involved and can easily tell whether the speech is potentially causes a danger of suicide. That part may be very hard, by the way. I'm skeptical about it. But if that's so, you could imagine a court saying, look, there would be negligence liability because speech to a particular minor where you are aware, you as the company are aware that the person is a minor and that might be harmful to the minor might be unprotected. So that, I think, is going to be where there's going to be a lot of debate about negligence and design defect type responsibility, even if you conclude, as Jess and I agree, one should, that the companies are presumptively protected by the First Amendment.
Yeah,
Yes, Mark. Very
quick
quickly,
comment.
Mark, because we have 2 more questions from audience members.
Good. A quick comment. I think the public is now thinking that the AI companies are very much like the social media companies, and they have to be reined in some fashion. But I think the public was disappointed when they found out how little social media companies were actually liable for under the law. It wasn't just Section 230. It's even without the Section 230 protections.
Right.
Information, racism, all that other stuff that they went out of their way to protect against was not illegal speech. Same is true for AI companies. You know, the public is gonna be very surprised when they discover that applying the law to the AI companies doesn't get them the results that they think they're gonna get.
Okay, very quickly, we're near our time. I assume it's okay with the 3 of you if we go a couple minutes over.
Sure.
We have a question about the New York digital replica law. So Jess, how is the term "in place of work the individual would otherwise have performed in person"? How is that defined in the law, if you know? And does its scope raise concerns about being overly broad and vague?
I apologize. I'm not specifically sure with regards to New York. I will say I know they're trying to model it off of the SAG-AFTRA CBA and the way that SAG-AFTRA goes about it. Sorry, I'm pulling that back up for you. Okay. In place of work, the individual would otherwise have performed in person. The way that SAG-AFTRA talks about it is, it needs to be very specific use cases. So if you've articulated that you are using AI to de-age someone, you will have to, in order to do that de-aging process, you're going to have to take a scan of their face, essentially. What they're trying to prevent against is, now that you've licensed it for this use case of de-aging, you can't then go and use it for another separate use case where you don't even now, if you want to say like, look, we can just AI this person, the same performer, we can just use that in an advertisement for the trailer of this movie now, or if we're going to use it in some other context. Each one of those use cases needs to be sort of negotiated individually, especially if you are now opting to not use an actor, a actor as like a live human actor in place of where you would use it for AI. So I imagine that's probably where this is going to go in New York. And are there concerns around whether it's too vague or broad? I think so, and I think we're already starting to see that play out, at least in the collective bargaining agreements taking place with SAG-AFTRA and some other labor unions. But I think the New York one just recently went on to the books, so we're gonna have to see how that ends up playing out. And I'll admit, I don't negotiate these contracts. I'm kind of like moonlighting right now in the entertainment space a little bit. So I would love to hear, honestly, from experts who do these contracts and who deal with entertainment folks as well, performers, their concerns too.
Okay, and then just one other question has been submitted regarding algorithms, and can algorithms be subpoenaed in trial? Interesting question. Anyone have a thought on that?
Well, an algorithm can't be subpoenaed, just like a
Waymo not to appear, but can the algorithm be required to be placed in evidence?
I would think that would be very common. Now, if the lawsuit is your product is defective and it caused harm the following way, of course you need to understand the algorithm. If the product, if the claim is the algorithm violates anti-discrimination law in various ways, of course you need to do that. Now, how you're actually going to implement that is complicated. First of all, of course, even if you it may be that it's too voluminous to be able to use it in a meaningful way. It may be that it is a trade secret, in fact, perhaps the trade secret of the company, and there would be restrictions on it. Maybe that as a practical matter, what you would do is, rather than subpoena an algorithm, you would maybe appoint some expert, maybe a neutral expert who would then look at it and answer certain questions or what have you. Sometimes you may just subpoena the person most knowledgeable about it in the organization. But a lot of these lawsuits are at their heart going to be all about figuring out what does the algorithm actually do, and there would have to be some sort of discovery of that in one way or another.
Yeah, but I think it's important to recognize the limits of that, because trade secrets is a very strong barrier to getting at the details of these kind of. There's one case in Michigan, the Loomis case, or it was Wisconsin, the Loomis case, where they looked at the recidivism score that was provided, and the plaintiff said, "I want to look at it," and they said, "No, sorry, can't do it." How can I tell whether it's accurate then? They said, "Sorry, secret." Yeah, so it's a really tough barrier to get over.
So I lied, and there was one other question that I neglected.
You hallucinated.
Didn't notice. I hallucinated. There's a lot of that going on these days. Are social media influencers considered to be public figures? I guess the question is, what is the standard for what is a public figure?
So I don't know of cases that specifically focus on that. There may very well be some. Historically, this issue has arisen with regard to media figures of various kinds, and the answer is there are formal rules. One way you can be a public figure is if you have achieved pervasive fame or notoriety. Of course, that's a judgment call and depends how pervasive. And sometimes the question is it absolutely pervasive throughout all of society or just among the particular community involved there? And I think the answer is different state courts look at that differently. However, the more common way that people become public figures is through being limited purpose public figures. They voluntarily inject themselves into some debate, and they become public figures for purposes of commentary germane to that debate. So if, for example, somebody gets involved in a political campaign, let's say some ballot measure having to do with, I don't know, gender identity, then if somebody says, oh, this person has said these offensive things, or this person has made these false statements in the past that show that he's untrustworthy as to this, then in that case, he'd be a public figure for those purposes. But on the other hand, if the allegation is this person was, I don't know, engaged in some garden variety extramarital affair, that might not be relevant to that subject matter. So influencers, often what they do is they get themselves involved in public debate. Sometimes if they're kind of influencers having to do with, I don't know, with entertainment, they may get themselves involved in not political debates, but entertainment-related debates. Right. But at that point, they may very well be limited purpose public figures. But again, I think this is a situation where we just apply existing law. Sometimes it's kind of vague, but the law has made its peace with that. And of course, we also recognize that the rules are different in different jurisdictions.
All right. Well, I think we're going to have to leave it there. Thank you all, Jess, Mark, Eugene, for taking the time to be with us. And thank you to our audience who have hung in with us this 97 minutes. So appreciate everyone's participation, and have a good rest of your day.
Thanks very much for having me. Yeah.
Thank you.